I'm Drew Stevenson, and this is a lecture for my professional responsibility class about Model Rule 5.2, which covers the responsibilities of a subordinate lawyer. This is part of a set of rules, 5.1 to 5.7, that are really about the ethical issues that come up with law firms or law offices that might be a government office in terms of when one lawyer might actually be subject to discipline for something that one of their colleagues does. And most of the time, you're not. And so if you're a new associate after law school at a firm and another associate who's at the same level as you commits an ethical violation, we usually won't impute that to you individually, but there can be responsibilities for partners and so forth and managers at the firm. And we can have responsibilities for subordinates, and in the sense that it's not going to be an excuse for of clear violation that you were doing what you were told. And so there's sometimes in legal circles we call this the Nuremberg defense, because at the Nuremberg war trials after World War II, everybody, all of the German government officials who were put on trial for their participation in the Holocaust, the genocide that occurred in Germany in World War II, basically said that they were just following orders. And so that the big takeaway from 5.2 is that that doesn't apply here. And for the most part, you are going to be responsible for your own ethical violations, even if your boss is the one who told you to violate the rule. So let's look at the specifics of the rule itself, the text of the rule. A lawyer is bound by the rules of professional conduct, notwithstanding that the lawyer acted at the direction of another person. That's 5.2a. In other words, if you are brought before a disciplinary committee because you violated a rule, you're not going to get out of it just by saying that the partner told you to, or that it's not your fault because someone else made the decision. That's kind of the clear import of the first section. And should be the easy point of this for test questions. Secondly, a subordinate lawyer, this is kind of the exception, does not violate the rules of professional conduct if that lawyer acts in accordance with a supervisory lawyer's reasonable resolution of an arguable question of professional duty. So just to make sure that you understand the two prongs of this, if you violate the rules and it's a clear violation, it's not going to be an excuse that you were pressured to by your boss or ordered to by your boss or something like that. Now, the boss, as we saw under Rule 5.1, might be subject to discipline for telling you to commit a rule violation, but that doesn't let you off the hook. But let's say it's an unclear question. So I think the most ambiguous area of all the model rules is probably about conflicts of interest. And so you have a close question and that where reasonable minds could differ, and your supervisor or the partner ultimately has to make a decision and tells you what to do. You won't be subject to discipline if you let your supervisor resolve an unclear issue. Even if a disciplinary authority later on says, by the way, we think the right answer is the other way, is the opposite of what you did. For example, the common scenario is, we think that this is a disqualifying conflict of interest, but it was an arguable, a close case, and the rules weren't quite clear in this case. And so in that case, and kind of that case only, then you will cover your back if you are deferring to what your boss says. Okay, I'm just going to hit the comments that you're likely to see turned into test questions here. So comment 1, although a lawyer is not relieved of responsibility for a violation by the fact that the lawyer acted at the direction of a supervisor, that fact may be relevant in determining whether the lawyer had the knowledge required to render conduct a violation of the rules. In other words, some of the rules, other model rules, talk about knowingly doing something. And so it's possible that you weren't really informed of what was going on. You were just a lawyer. Your supervisor asked you to do a specific task and didn't explain to you what the other things that were going on in the representation. And so it could be a defense that even though you wrote a memo, you dropped something off at court, you sent a letter to the client saying XYZ, or you disclosed certain information to the other party during discovery, because you weren't really aware of what was going on in the case and wouldn't have been able to know that it was a violation, that of course could let you off the hook, right? Because you could still get off the hook if you lack what in criminal law we would call the mens rea, or didn't have the knowledge, satisfy the knowledge requirement in another rule that has a knowledge requirement. So here's the example they give in comment 1, and I would always urge you to focus on the examples in the comments, because the MPRE examiners love to turn these into multiple choice questions, and so do I on my exam. If a subordinate filed a frivolous pleading at the direction of a supervisor, the subordinate would not be guilty of a professional violation unless the subordinate knew of the document's frivolous character. So if I can give you, break this down into 2 hypos situations, you will find when you're in practice that at some point when you're headed out the door and you've got your suit on and your briefcase and so forth, that someone will stop you as you head out the door and say, hey, are you headed over to court? I was wondering if you could drop off my brief or my pleadings at the courthouse as well, at the clerk's office too. And you're going to say, sure, right? Because you're going to the courthouse anyways, and you're just going to pass in what somebody else handed you, and you haven't even read it. Well, we're not going to hold you responsible for being the one who filed a frivolous pleading if you didn't even know it was frivolous. On the other hand, if you worked on this pleading and you discussed it with the supervisor, like this is a ridiculous case and it's not supported by the facts or the law, and then the supervisor says do it anyway, then that would be a violation, right? Because you know that the document is a frivolous pleading. Comment 2. When lawyers in a supervisor-subordinate relationship encounter a matter involving professional judgment as to ethical duties, the supervisor may assume responsibility for making the judgment. In other words, in these close cases where it's reasonable minds can differ, then you can defer. It makes sense to have the subordinate defer to their superiors. Otherwise, we would be paralyzed, right? A consistent course of action or position could not be taken by the firm. Now, if the question can reasonably be answered only one way, like if this was a clear ethical violation, then the duty of both lawyers is clear and they are equally responsible for fulfilling it. And so if you are only half listening, you may want to stop and read that again. If it's a clear violation and you have a boss and a subordinate lawyer, like a junior associate who's right out of law school, if it should be clear to anyone that this is a violation, both of them will be equally responsible for the violation. However, if the question is reasonably arguable, someone has to decide upon the course of action, and that authority ordinarily reposes in the supervisor, and a subordinate may be guided accordingly. In other words, the ABA didn't want to create a situation where you're going to have to push back against your supervisor on every time there's something arguable that comes up, or a close call ethically, just to cover your own back against cover yourself against future disciplinary actions. If it's something that's an really arguable point, then we expect subordinates to defer to their superiors. So, and then here's our second example. Again, pay attention to these, and this is in comment 2. If a question arises whether the interests of 2 clients are in conflict under Rule 0.7, so conflict of interest, lots of ambiguity under that rule, the supervisor's reasonable resolution of the question, should protect the subordinate professionally if the resolution is subsequently challenged. Okay, so I think you get the idea. Here's a quick review question to see if you've even been paying attention. Can a lawyer avoid disciplinary action for a clear ethical violation by claiming that the improper conduct was undertaken at the direction of a supervising attorney? Yes or no? Hopefully you know the answer to that. That's supposed to be an easy question. If not, I think you need to read the rule again and maybe review this video again. And that concludes our lecture about Model Rule 5.2.